But basically, I just want to start with the usual warning that you'll hear from lawyers like me, that this information session provides general legal information that does not constitute a legal opinion or legal advice. You're advised to consult a lawyer to obtain advice about your specific situation. Please consult the list of useful resources that will be posted at the end of this session, the last slide in this session. So just to be clear, when I'm speaking to you all, I'm not creating a solicitor-client retainer. I'm not here to provide you with advice on any of your specific cases. I just want to help you as members of the public if you intend on self-representing yourself in court in a civil proceeding. So we can maybe get into the next slide. Representing yourself in court, how to get ready. I'll just tell you a bit about myself. My name is Patrick Simon, or Simon. I work at Weiss & Hunter LLP. We're a litigation and municipal firm just west on Bronson, somewhat west of Ottawa. My year of call to the bar is 2014. I started as an articling student in Toronto doing administrative law at the federal court. Since then, I've transitioned to the Ontario Superior Court of Justice as a civil litigator. I mostly do real estate disputes. I don't do much personal injury. I don't do much corporate, commercial, contractual litigation, but I do sometimes do both of those. But I prefer real estate dispute and construction liens. So that's where I spend most of my time. That being said, the Superior Court deals with the same rules, deal with matters of a personal injury, negligence, professional negligence, commercial disputes. It's always the same rules of civil procedure. I can do those things. And if any of you in this Zoom chat or presentation have issues in those fields of civil litigation, this presentation could be helpful to you. And I want to thank the Ottawa Community Foundation for its financial support. And we can move on to the next slide. So I just want to start with the judge. The judge is the judicial officer. He's usually seated a bit higher than everybody else in the room. He makes a decision, or she makes the decision if the judge is a woman. She has to be, or he has to be independent and impartial. So usually they're nominated and they have tenure. They're not elected for 4 years. They're not there to make people happy. They're there to apply the law and interpret contracts and interpret the situation and give a final judgment. A jury is rather rare in civil proceedings. I have never been in a jury trial, and I may never be, and many civil litigators are never participants in a jury trial. It's usually more of a criminal thing, but it does happen sometimes, especially in personal injury cases. Where a catastrophic motor vehicle collision causes millions of damages to an individual. Sometimes either the insurance company of the person driving the motor vehicle who entered into the collision will ask for a jury trial. When there is a jury trial, basically members of the jury are lay people. They're lay people in society, and they are usually only asked to make findings of fact, not findings of law. When it comes to findings of law, the judge who will be present in a jury trial usually answers questions of law. A master is like a judge. In fact, we lawyers call them judicial officers. They're usually in charge of procedural motions before your action makes its way to a trial. And we'll explain the various stages of an action later. But the master is usually there, for example, to correct a style of cause, or what we call a title of proceeding. If someone's name isn't correctly mentioned, or if they're not mentioned at all, a master can come in and adjudicate on those issues. So masters are very important for lawyers like me, because a lot of times when we go to court prior to trial, in fact, maybe 70–80% of my time in court is before masters to take care of issues, procedural issues, or maybe to help advance the case forward if there are disputes as to how the action is to prosecute itself before trial. Court services officers, they contribute. I'm just going to read the slide. They contribute to the proper conduct of proceedings in court. The officer's primary duty is to assist the presiding judge. These court services officers, when I go to court, they're usually seated in the back of the room. They come in to add water if someone needs water, if the judge needs water, if I need water. Maybe sometimes some people in court get agitated. I haven't seen it yet, but I've heard of it. When they do, potentially the court services officer would get up and tell whoever's agitated to stop. If a judge somehow someday, and this is very rare, and I've never seen it, but if a judge somehow declares a contempt of court, I have a feeling the court services officer would be asked to potentially get the person who's in contempt out of the courtroom. The court clerk is an incredibly important person. You want to be nice to that person. They're the relay between the judge and the parties. So often the court clerk, they'll plan hearings, they'll announce the rules of court, they pass various exhibits to the judge, they ask witnesses to promise to tell the truth, so they swear witnesses in. But they do all that, and they're the ones that'll get you, that may schedule your hearing if you have a motion or a trial. It's important to be very courteous to everyone, but the court clerk is good to have on your side. Court reporters, they transcribe into writing everything that was said and done during the hearing. So you'll see them usually sitting in front of a judge in the courtroom. They're not looking at you or the judge, they're looking towards like in the perpendicular fashion, and they're usually just typing, or they're speaking into a machine, and they're writing or they're writing the transcript. Transcripts are important if you ever want to do an appeal, because you want the judge, the Court of Appeal judge, to see or read what happened in the lower court. Lawyer. So the lawyer, if you are self-represented, that means that the lawyer will probably be, or rather his client will be adverse in interest to you. You may not look highly upon a lawyer if you're a self-represented litigant in an adversarial proceeding. But basically the lawyer is there to advance his client or her client's interests. They know the rules. They will draft statements of claims and defenses and pleadings, as they're called, for their clients. They will draft facta or legal arguments for their clients. They may assist in drafting affidavits and putting the proper evidence in front of a judge so as to put their client's best foot forward before the judge. So that's what lawyers do. They represent their clients. They're agents for their clients. They negotiate for their clients. And they represent their clients at hearings, and they argue on behalf of their clients. In an action, if you decide to commence an action for damages, you will be called a plaintiff, a self-represented plaintiff. If someone is starting an action against you for damages or an injunction, you will be called a defendant. So you will be brought to court to defend against someone seeking either an injunction or damages against you. Sometimes in superior court, but rarely, there are people called interveners. This happens more often in courts of appeal and Supreme Court of Canada. Interveners are basically people whose rights are affected by the decision being made, but they're not parties to the action. This morning I gave an example. So let's say you have a right of way over your neighbor's land to get to the highway. And that right of way continues behind your land to other people's lands, and they also need that right of way. And you're trying to bring an application or an action to have the owner of the land remove an obstruction from the right of way. Well, you're not going to be starting an action against the neighbors behind you, but if you win that, the neighbors behind you may be benefited from your action. Or if you lose and the obstruction stays, then it'll be to their detriment. So they may be interveners to that action. Usually interveners are at the Supreme Court of Canada. That's where you often find them. And they're usually there to represent interest groups that want to assist the Supreme Court of Canada in advancing some policy perspective. Finally, there's applicants and respondents. Those are in relation to something called an application. An application, I do mostly applications. That's rare. Usually lawyers do more actions for damages. Applications are usually for declaratory relief. For example, if you want to declare that you have an interest over your neighbor's land, you don't start an action because you don't want money. You start an application because you want a declaration and potentially an injunction. And that's what applications are for. Applications are very similar to motions. You start with a notice, you have evidence only by affidavit, and then you have a factum, which is your legal argument. And you go to court and all you do is explain the facts through exhibits, and it's a lawyer that does most of the job. There's no viva voce, or rather there's no oral evidence or swearing in of testimony or witnesses during an application. It's an affidavit with exhibits and then a factum. The respondent would be like the defendant. It's the person who wants to fight the application, or adverse in interest to the applicant. The rules. I cannot stress the importance of the rules of civil procedure. If you intend to be self-represented in the Superior Court of Justice, you really should familiarize yourself, or try to familiarize yourself, with the rules of civil procedure. They're available online. You can also buy an annotated Ontario Civil Procedures book. I have one. I buy a new one every year. It's the most important book for a lawyer like me that does civil litigation. It contains all the rules as to what you have to do to prosecute your action. It will not tell you, it will not give you legal arguments, but it will tell you how you are to bring your illegal arguments to court. It is very important, and breaching these rules could cause you to lose your right to argue or to have your day in court. So I can't stress how important the rules of civil procedures are. The forms are important too, but you can get assistance from that at the court counter. But really, the rules of civil procedure, if there's one thing I can stress to any of you today, if you're going to be self-represented, know your rules. You'll get a lot of respect from the court and from opposing counsel if there's a lawyer on the other side. There's also a note I just want to bring to your attention. Recording the parties, judges, and court employees during any hearing of the Superior Court is strictly forbidden. So just to keep that in mind when it comes to the rules, don't bring a recording device to the Superior Court of Justice. They have a transcriber there, like a court transcriber there. So don't ever bring a recording device to the court. And keep in mind, you're not expected to present your case as effectively as a lawyer would. Every member of the judicial apparatus, including lawyers, they know that you're self-represented, and they know that that means that you're not as sophisticated as a trained lawyer. And that, I don't mean that to be in a belittling way. All we mean is that you're not a lawyer. So everybody takes that into account. Judges do, court clerks do, and opposing counsel does too. And the obligations are a bit different when you're against a self-represented litigant. So don't expect to know how to effectively plead your case, but knowing the rules will certainly help. Etiquette and rules to follow, those almost as important as the rules themselves. This is the time to wear a tie, try to put a jacket on, nice clean shirt, preferably pressed. You don't need to wear a gown. In fact, I don't think you can wear a gown like a lawyer does, but wearing a suit will help. If you don't have a suit, if all you have is clothing that is not a suit, tell the judge. Tell the judge, I wish I could wear a suit, I just can't. And the judge will understand, but you'd be better off telling the judge or the master. Don't wear a hat or a headscarf or anything else on your head unless it's for religious reasons that you're wearing those. Don't chew gum. Please don't smoke cigarettes in court. Don't wear sunglasses. There's no need for sunglasses in court. There's no sun in court. Do not wear clothing with words or images that might offend. Just a judge as your honor. It's not your worship or your majesty, it's your honor. Or you can say Mr. Justice or Madam Justice. Stand when you speak to the judge, and speak. When you speak, I can't stress that enough. We know that you are probably going to be stressed a bit, or a lot. this hearing that you're going to be participating in, you may be going against a trained lawyer, you may not, but no matter what, it's probably going to affect your rights, your proprietary rights, or your contractual rights, or if you've gotten hit by a car, well, then your rights to damages. So you're going to be stressed. Notice or try to breathe. Try to pause, drink water. If you're very nervous, tell the judge. And the judge sometimes will then feel more prone to stop you because they're trying to write down what you're saying. And if you see that a judge is not looking at you and writing down, that's a good sign. If the pen is on the ground and they're just staring at you like this, that's a bad sign. So speak slowly, make sure you're heard. The whole purpose of going to court is to be heard. That's the purpose. If you speak too quickly, they will not hear you, or they will hear you, but they won't understand you. Don't interrupt a judge. If a judge asks you a question, that means they're interested in what you're saying, or they're interested in the question they're asking, which means that it's important for them. If it's important to them, it's probably going to be important to you. So don't interrupt the judge. When speaking in court, try not to, or actually don't speak to anybody else but the court or the judge, and if needed, the court clerk. This is not the time to start talking to opposing counsel or opposing party. If you know the opposing party, keep it for outside. Don't talk to the opposing party in the court. Try not to use people's given name too often. Lawyers, you'll hear us say, my friend so-and-so, my friend so-and-so. Use the following formulas to address court employees. For the registrar, it's Mr. Registrar. For court services officer, it's Mr. X. Mr. If you can read their name, just try to say their name. I don't know why you'd want to speak to a court service officer. For the reporter, Mr. Court Reporter, did you hear that last part? You stopped writing, Mr. Court Reporter. Again, there's not that many reasons to talk to a court reporter, but if you do have a reason, that's how you should address them. Don't chew gum. Don't eat or drink during a hearing, with the exception of water. Do not swear. Do not use vulgar language. Make notes of what the other party's points are, and if some of them are very controverted, keep them for your reply, and don't ever repeat in your reply. Virtual hearings. I had never done a virtual hearing until March 2020 when the COVID pandemic created an emergency in Ontario. But because of this health crisis, it is highly likely that your next hearing will be held virtually. Mine are now. I haven't stepped in a courtroom since March. I miss it because that's what I like to do. So the following are some helpful tips for your virtual hearing. Test your microphone and your camera before your meeting starts to make sure they're all working, or else you won't be heard, and that's the whole point. Make sure that the device you're using to join the meeting is up to date. This will prevent last-minute technical problems. Connect to your meeting 5 minutes in advance, whether by telephone or video conference. Sit in a place with a neutral background and face a source of natural light. Keep your microphone on mute when you are not speaking. Steps to your case. Chances are, if you're in civil litigation, and it's not a real estate dispute like what I do, you will be instituting a claim or defending to a claim, or defending a claim. Usually if there's negligence, nuisance, any tort, any motor vehicle collision, most contractual interpretation, so corporate commercial litigation is all claims. When it comes to real estate disputes, there's also a lot of claims, but there happens to be a lot of applications too. So when a claim is started, when a plaintiff files, filing means serving first, what's called a statement of claim. In your statement of claim, you will have your cause of action. So what is it that you're claiming from someone? Well, you're claiming a certain amount of money because that person did a wrong. What is the wrong? Breach of contract, negligence, nuisance, assault, I don't know. So you have to explain what your cause of action is and what the damages are caused, or what you're seeking as damages for said cause of action. If you fail to plead your cause of action properly, then chances are, if the opposing party is represented by counsel, they may bring a motion to strike your pleading. And that I do sometimes. So that's why you should know the rules. Defense and reply. The defendant files a reply to rebut and reply to the claim. So a defense is not a reply. A defense is basically your way of saying, is your way to deny the allegations contained in the claim, or to cite that you have no knowledge of certain of the allegations in the claim, or to admit some parts of the claim so as to narrow the issues. And once you filed your defense, then, or once the opposing party has filed a defense, then you have a right to reply. And you only reply if something new came out in the defense. So you don't repeat your statement of claim in a reply. It's very rare, by the way, that lawyers file replies, but it happens sometimes. Once the statement of claim, defense, and reply have all been filed, the next step can be mediation. Mediation is compulsory in litigation, civil litigation in Ottawa. It's also compulsory in Toronto and the County of Essex, so Windsor. It's not compulsory anywhere else, but it is very useful. And it's useful because it provides you with an opportunity to speak to a mediator who happens to be someone that you choose with opposing counsel or opposing party. They tend to be very sophisticated. You get to choose them. So they should know about the law behind your contentious issue. And they will give you an unbiased opinion of how to resolve and how strong or weak your claim is. So I would take mediation very seriously. It's a great opportunity to try to resolve without having to spend on fees for a trial. Discovery is also incredibly important. That is an opportunity for you to examine the opposing party under oath. And it's the only opportunity you'll have before a trial. So if you need admissions, if you want to start narrowing the issues, or if you want to ask for undertakings because you want more evidence, discovery is the way to do it. Setting down for trial. Once the mediation and discovery have been completed, you are now free to set down your action for trial if you have not negotiated a settlement yet. And the trial is the last part of the action. That's when you go in front of a judge and you argue your case and you tender the evidence. Before going to trial, you will get an opportunity to appear before a judge that will not be the presiding judge in your trial. And that's called a pretrial conference. A pretrial conference is very similar to a mediation, except it's not a mediator, it's a judge. And that judge will tell you what their opinion is of your action, or the defense, and the defense. But it's because their job is to try to settle this without the need for more court resources and more judicial intervention. Motions are like applications. So motions basically are small hearings within the wider application, but they're not trials. Motions can be procedural, for example, adding a party to the litigation, removing a party to the litigation, changing the request asked, maybe changing your style, your theory. So maybe you want to add, you don't want to just sue for negligence, you want to also sue for nuisance or for trespass, because I do more real estate litigation. So if you want to add a cause of action, that's through motions. Motions can also be used to strike pleadings. If the litigant or if the litigant is the plaintiff and they didn't do a proper job with their statement of claim, then it could be struck through motion. There's also something called motions for summary judgment. That's to get rid of or to dispose of the underlying action without going to trial, but by doing it through motion. The trial is the last portion. The trial is by far the most expensive and cumbersome part, especially for lawyers, but I'm sure for self-represented parties as well. This is where you're in front of a judge, you tender evidence, you give oral evidence, You get examined, you get cross-examined, and you do that for all the witnesses until you are done pleading your case. There's seldom civil trials. There's less and less of them. Only about 3% of actions are resolved through trial. Like in 4 years, I've done 3 trials. Preparation for trial. Preparation for trial. Always, 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 in civil litigation, speak with the opposing party. As lawyers, we have an obligation to try to settle or try to not pressure, but to assist our client in settling. Because you never know what's going to happen at the outcome of a trial. But if you're the loser of that trial, and there is always a loser, or often, well, then you may have to pay your lawyer. And if you didn't get a lawyer, you may have to pay the winning party's lawyer's fees up to 90% if an offer to settle was made according to Rule 49. Go read those rules. Rule 49, very important rule. Review the evidence and familiarize yourself with the evidence. Judges aren't usually convinced by stunning oratory. They're convinced by the evidence that is tendered to them. Prepare the materials that you want to submit to the court. In the case of a motion, you must provide a motion record. And it's the same thing for an application. A motion record is pretty simple. Well, for a lawyer, it's actually not that simple. You need a notice of motion stating what the relief is that you're asking the court. You need an affidavit, which tenders the evidence. And you need a factum, which is your argument in law. Factums are not necessary, but they're very helpful. Prepare your oral arguments and submissions to the court. The argument must not vary too widely from the arguments in your factum. That's why you should have a factum. The judge will read your factum. If you don't read your factum and you don't have a factum, basically the judge may get angry because he's going to be tendered all this legal argument without ever having had a chance to read it before. That's not a very good way to win your case. It's not very good advocacy. Ordinarily, the person who started the proceeding, who's the plaintiff, will go first with his initial argument. The other person, the defendant, will then respond. After the response, the plaintiff may reply, but that is not an opportunity to repeat everything that was said during the initial argument. In a motion, the person who made the motion will be entitled to speak first. The respondent will then respond, and the moving party, lastly, will be entitled to reply. And don't ever repeat what you said in your initial argument in your reply. That's the best way to make a judge very angry. Oral submissions and decision of the court. When you're making your oral submissions, either your opening submissions or your closing submissions, or if you're doing a motion or an application, your submissions in support of your motion for your relief, use notes. I always bring 1 page of notes, never more than 1 page. I shouldn't say never, never say never. Sometimes 2 pages, but often just 1 page. And I have some of the most basic and most important facts, and then the case law supporting those facts, or supporting what I'm asking for from the facts. The judge may ask you to focus on one aspect of the legal problem before him. That's a good sign. That means they're interested. That means they want to know more about this. And it probably means that they're convinced on those other problems. If they weren't convinced, they'd allow you to speak, but they probably wouldn't write. If the judge asks you a question, make sure to answer it. This point is probably very important to them, or else they wouldn't be asking you the question. Be courteous to the judge. Don't ever say, well, it's obvious, Your Honor. That's a bad idea. Even if you do not agree with the judge's comments, be courteous. If the judge asks you a question or requests clarifications, that means that he or she has not understood. And if they haven't understood, then you haven't done your job. Your job is to make sure that they understand your point of view, especially if it's well-grounded in the law. You can't ask for more than that. If you do not know the answer to the question, you can ask for time to research. I've actually done that once. So even lawyers do that. Don't know the answer, you ask for a quick recess. You go to the library and you search very fast. You do not want to avoid the question or fail to answer it. However, if you don't know it, you just say you don't know it. Don't create an answer. It'll just make you lose respect and credibility in the court. And sometimes that's what I answer to a judge. I don't know. I did it last week. A judge asked me a question. They asked me point blank, Mr. Simon, do you think there's a fraud? I said, I don't know. I don't know. What do I know? Here's the evidence. You know, sometimes you just got to be honest. Actually, you always have to be honest. It is not appropriate to ask the judge a question or to ask the judge to explain his or her position. However, if you do not understand the judge's question or you do not understand a legal concept, you may ask the judge to clarify. And the judge usually will. The judges like to make sure that self-represented litigants, even lawyers, understand a concept. They just can't give you advice on how to argue. When you make your submissions and reply to the other party, do not repeat yourself. Now, I'm repeating myself, but I want to make sure it's clear. Don't do what I'm doing in court. Don't repeat yourself. So don't repeat yourself. Limit yourself to rebutting new points raised by the opposing party. The judge may deliver his or her decision orally at the end of the hearing. That's called a decision from the bench. Or take time after the hearing to consider the evidence and arguments and deliver the decision later in writing. That's called reserving the decision. Often when there are lawyers and the issue is complex, judges will reserve their decision. Even if the judge's decision is not in your favor, remain courteous and thank the judge. Do not celebrate during the hearing. You can do that later. Bilingual proceedings. So I'm very cognizant that this is an English presentation, but it's made with the Association des juristes d'expression de langue française. So there's a bilingual component, especially for those of you who either want to argue or to have your hearing heard in French, or if you're defending and you're presented with a pleading that is in French, you can ask for you as an Anglophone in Ontario will be allowed to draft your defense in English. But that being said, just a reminder that Section 126.1 of the Court of Justice Act entitles a party to require that the proceeding be conducted as a bilingual proceeding. When we say bilingual, what we mean is English or French. There's no other language that is encapsulated or that is included in the concept of bilingual proceeding. A bilingual proceeding may be requested only in designated bilingual areas. So there's not many of those, but Ottawa is one of them. Toronto is two. Prescott-Russell is, the county of Essex is, and there's others, and you can find those pursuant to Ontario Regulation 5301. If your statement of claim is not, if you don't ask for bilingual proceeding in your statement of claim, you can make an oral statement in court, or you can file a written statement with the court. For interpretation services, you must request interpretation services for your hearing as soon as you realize they will be necessary. If you need interpretation services for your hearing, contact the court interpretation unit at the courthouse where your case will be heard. When you request interpretation services, it is important to provide the following information. The language of interpretation. Who is requesting interpretation services? Is it a witness? Is it a lawyer? Date and time when interpretation is needed, court location, and any other relevant information as asked by the court interpretation services provider. A translation service is provided for the order where needed. In-person hearing. Since COVID-19 in March, I have not had an in-person hearing. But there are in-person hearings. There are some. They're usually for family or for criminal proceeding. But from what I understand, masks are mandatory if you're appearing in court. Social distance is also being practiced, and there's a maximum number of people in the elevators in the courtroom, and that is 2. It can't be more than 2 people in the elevator. That wasn't so before March, it's so now. To find out what measures have been put in place, please ask the courthouse where your case will be heard. Arriving at the courthouse. So yeah, 90% of success is showing up. That's what I tell all my clients. You must first go through security. They keep the following points in mind. You must go through a metal detector. Purses, backpacks, and so on will also be x-rayed. Anything that is considered to be dangerous or to be a weapon will not be allowed into the courthouse. If you're in possession of an item that security considers to be dangerous, they can ask you to leave and come back without the dangerous item, or to give them the dangerous items. The things taken from you will not be returned. The following are examples of items that are forbidden in the courthouse: knives or sharp or pointed items, like utility knives or scissors, flammable items, firearms and ammunition, and other items such as alcohol, chains, or handcuffs. Everyone who enters the courtroom, or the courthouse, must go through security. So rather, all laypersons that go to the courthouse must go through security. Officers of the court, like myself, do not have to go through security. So you may find yourself ahead of or behind the opposing party in your case while you're waiting in line. If you're not comfortable or afraid of the opposing party, you can take a support person with you to your hearing. If you are not sure of your courtroom number, you can go to the information counter and ask what room your case is in.